testing 1 2. Testing 1 2. Testing.
Good morning. This morning I'll be making an announcement on the conclusion of Mr David Bain's application for wrongful conviction and imprisonment. At the outset, let me say that this case has been one of the most complex, unique and high-profile cases New Zealand has ever known. While many New Zealanders hold strong views on the case, the complexities of the evidence and the opinions that the evidence have given rise to are such that those views are likely to continue to be firmly held without clear resolution. One thing on which I like to think we can all agree is that at some point, some finality needs to be achieved. This is a process that has been going on for many years. It's now more than 22 years since the murders took place, and nearly 6.5 years since the application for compensation was made. On the morning of June 20th, 1994, Margaret, Laniette, Arawa, Stephen and Robin Bain were found dead in their Dunedin family home. In March 1995, David Bain was convicted on 5 counts of murder in the Dunedin High Court. The case was then subject to a number of appeals and reviews, all of which were unsuccessful. Mr Bain then appealed to the Privy Council, who in 2007 quashed the convictions and ordered a retrial. The retrial resulted in Mr Bain being acquitted in June 2009. In March 2010, Mr Bain lodged his application for compensation with the government, who commissioned a report from retired Canadian Judge Justice Ian Binney. That report was peer-reviewed by QC Robert Fisher, who found it to have included fundamental errors of principle such that it would be unsafe to act upon it. That finding was not accepted by Mr Bain's team. In February 2015, I reached agreement with Mr Bain that these 2 reports would be put aside and that Cabinet would take a fresh look at the claim. I subsequently appointed Mr Ian Callanan QC, a highly respected retired judge of Australia's highest court, to provide advice on Mr Bain's claim. I received Mr Callanan's draft report in September 2015, and in accordance with the process put in place at the time of Mr Callanan's instructions, the parties were then invited to make comment on the report before it was finalised. I received the final report from Mr Callanan on the 27th of January 2016. There have been ongoing discussions with Mr Bain's legal team since this time. Today I'm releasing Mr Callanan's report, which finds that Mr Bain has not established his innocence on the balance of probabilities. The test for compensation requires that the applicant proves on the balance of probabilities that they are innocent. This is a different and higher test than the one in the courtroom on which the acquittal was based. In court, the Crown must prove guilt beyond a reasonable doubt. It is sufficient if the defence can raise reasonable doubts that they're responsible for the offence. In light of Mr Callanan's advice, and the onus being on Mr Bain, there is accordingly no basis on which Cabinet could be satisfied that Mr Bain had met the established threshold for compensation for wrongful conviction and imprisonment. Accordingly, no statement of innocence or payment of compensation under the guidelines will be made to Mr Bain. However, the Crown recognises that the compensation application process has lasted nearly 6.5 years, and that this has been an incredibly difficult and complicated case for all involved. Reaching this point, I think it's fair to say, has taken longer than anyone would have wanted it to. In addition, since receiving Mr Callanan's final report, it's become evident that Mr Bain and his advisers do not accept Mr Callanan's findings. They have made it absolutely clear that they intended to legally challenge that report, leading to considerable further cost and delay in this matter. While the Crown is confident in the strength of its position in any such review, it's clearly desirable to bring finality to this case and avoid the cost and uncertainty of further proceedings. In my view, no one benefits from this matter continuing to drag on in continued litigation that would see more and more money spent in an effort to reach finality. That can't be in anyone's interests. In light of that, the Crown has agreed to make an ex gratia payment of $925,000 in recognition of the time involved and expenses incurred by Mr Bain during the compensation process and the desirability of avoiding further litigation. Mr. Bain has accepted this payment in full and final settlement of all matters. This resolution is, I believe, a pragmatic one that recognises the unique circumstances of this case and a desire on all sides to bring this matter to a close. Mr. Bain's compensation claim has not been a quick or an easy process. If this conclusion hadn't been reached, the matter would very likely have dragged on longer, with no more likelihood of absolute answers than we have today. I think we can all recognise that this is a case like no other. Even Mr. Callanan himself said he could not think of any other criminal case in which so many issues have been raised and in which there have been so many conflicts or inconsistencies of opinion and also of evidence. He went on to say that it was likely no one will ever know what happened. While the issue has divided opinion in New Zealand, I am satisfied that the matter has now at least been concluded. I want to thank Mr. Callanan for his report. He is a highly respected jurist, and I'm grateful for his considered advice. I rely on his own words to conclude. People in real life and the courts that adjudicate upon conflicting facts know that all of the questions cannot always be answered and all of the issues neatly resolved. This is such a case. Thank you. I'll now take your questions.
This compensation, it essentially is compensation, but in a different name, isn't it?
It's not compensation. Mr. Bain's application for compensation was unsuccessful. What we have agreed to do is make an ex gratia payment, and by that I mean a payment without any sort of legal liability to do so, to reflect the time, the costs, the difficulty of the process, but also, quite frankly, to avoid the continued litigation in this matter.
So it's compensation for the legal costs and the legal time, not for being imprisoned for that many years wrongly?
There's been no compensation paid under the guidelines, no compensation paid for wrongful imprisonment. It is an ex gratia payment. I wouldn't describe it the way you heard. It's an ex gratia payment, recognising the need to bring finality to the matter and the matters I've set out.
Can you in writing that it's full and final?
Yes, I do. We have a signed settlement deed between the parties.
Can you break it down into how the 925,000?
Look, in the end, it's a global settlement that's been negotiated between the parties. We haven't sought to attribute exact amounts, but we've made it very clear the parameters of it, and the Crown is comfortable that the payment recognises a fair settlement, recognising costs, time, complexity, and the desirability of avoiding further litigation.
Can you go into more details about what Judge Callanan found in terms of not meeting that threshold?
Well, Mr. Callanan, and you'll have the report, it's available now online, Mr. Callanan, in a very detailed report, it's around 150 pages in the main body of the report, has gone through, as you can imagine, the facts and the evidence in some detail, and has made clear in a number of occasions in the report the important distinction between the legal onus being on Mr. Bain to establish that he is innocent on the balance of probabilities and it not being sufficient to raise other examples of what might have happened or create other alternative scenarios, while that is often sufficient in a criminal proceedings where the onus is on the Crown. He's made the distinction that where the onus falls on Mr. Bain, he has to proactively establish that it is more likely than not that he is innocent, and he found that that threshold wasn't met.
It's a pretty huge amount, though, when you compare it to Taina Pora, who did meet the test.
Look, the two cases are entirely separate. We haven't gone through a process of assessing what the compensation figure wouldn't have been, because that's not appropriate. But I will say that in either case, the costs of compensation processes are paid. They were paid to Taina Pora. His were considerably lower because it was a short process, as we would expect it to be. In this case, as I think everyone recognises, it's been 6.5 years, a very long and complex process, and the costs were considerably higher. But in any process where the compensation claim was accepted, the compensation costs are paid. That was true for Mr. Pora. While this isn't compensation, we have agreed to pay the costs and, as I say, avoid future litigation.
Can you accept, though, that people will look at this and say Taina Pora got just over $2 million, David Bain gets nearly $1 million, that there seems to be a huge gap there and people will be upset about that?
I think people have to accept that every case is very different on its merits. Every application is considered very differently and the quantum is very different. As I've said, in any compensation payment, were one to be awarded, the costs of the compensation claim are always a part of that, and they're always going to be very different from Mr. Bain to Mr. Pora because of the length of the process. I think while there might be an immediate public desire to compare them, I really think it's unfair and inappropriate to do so. They are very different cases. The costs have been very different and they've been approached very differently.
Has there been resistance from the Cabinet or Justice Minister
time in terms of ever wanting to give David Bain compensation?
Well, Cabinet obviously makes all its decisions collectively, and this is a decision that Cabinet has made, and it has made it collectively. I think the Cabinet was certainly of the view that there is merit in bringing finality to this case. I don't think anybody, whether it's the taxpayers, Mr Bain, the family of the Bain family, benefit from this being dragged out. And for the reasons I've outlined, we see that no one wins if the matter continues to be battled out, more money is spent, and really with a very low likelihood of getting any greater certainty of outcome than we currently find ourselves with.
There's just been quite a difference, I suppose, with the Cabinet response to Taina Pora, totally taking into account the circumstances, but in their case, the full apology and the compensation relatively quickly compared with this.
Well, in Mr Pora's case, his innocence was very clearly established. In fact, it was found that he could have established it to a high threshold, so we were in a totally different position to begin with. Cabinet was very clear that once innocence had been established for Mr Pora, then the process was worked through in terms of the guidelines as we've discussed previously. This is a case where it is clear that there is nothing in front of Cabinet on which it can find that Mr Bain has met the threshold of innocence. So we're in a totally different situation than we were in. And we had a situation of either letting that continue to be fought out in the court or finding a way on which we felt a fair and equitable resolution could be reached, and that's what we believe we've done.
How much is this cost taxpayers in total, apart from the ex gratia payment? Do you have a total figure for all of the costs to the Crown?
We have the figures for the costs of each of the three reports, the Binney report, the Fisher report and the Callanan report, and they are in the information that you'll be getting at the end. I can run you through those numbers that they are all in the reports. I haven't got a figure to hand of all of the, for example, Crown law costs or all of the hearings and the likes. You'll appreciate that the process through the courts is very different and distinct from the process that I've been involved in, which is the compensation process, and we can certainly give you the total costs of the reports to date.
Yeah, so we'll run into the millions though, if you add up the Crown legal costs over the number of years plus the total of the reports.
Yeah, well, with the three reports alone, let me just check that number for you now so I don't guess. So Mr Binney's inquiry was $373,000 approximately, Mr Fisher's review $206,000, Mr Callanan's inquiry $298,000 approximately, and as I've said, that hasn't included legal costs and time from the Crown.
Was there blowback in Cabinet, or were there people in Cabinet who didn't want any payments to be made at all?
So we don't discuss the discussions made in Cabinet, as you know, but this is a collective decision of Cabinet and Cabinet stands by it.
So can you explain, so those costs was that figure one given to you by David Bain's camp?
I'm sorry, the 925?
Yeah.
So as I've said, it's a negotiated settlement that's been reached between the parties, and again, it's not legally appropriate, or in fact I'm not even legally able to go into the ins and outs of how that's reached, but it is a settlement that has been agreed between the parties, has been accepted between the parties, and represents full and final settlement of all claims of Mr Bain in respect to his conviction.
And obviously they had sought more than that.
I'm not going to get into that, I'm prevented legally from doing so.
When you made the comparisons between Mr Bain and Taina Pora, you said there's a different, Taina Pora didn't have the same costs. But in fact, his settlement was nothing to do with costs, was it?
Yes, it did include that.
Wrongful imprisonment, though, which is quite a different thing.
So look, it's really not the time to get into a discussion of Mr Pora's claim, but what I will say to you is that applications for compensation, when the test is made, it hasn't been made for Mr Bain, when that test is reached, then the compensation package combines three elements: a cost per year for time in prison, an amount for other non-pecuniary losses, plus an amount of pecuniary losses, which is all of the costs included in that. So that is always included in the global compensation package. And obviously the length of time spent in the compensation process is very relevant to how big that is. When you have a 6.5-year process, there are considerably more costs involved than when you have a 1-year process.
For wrongful conviction, then isn't it just, aren't you saying it's a compensation for his costs in relation to his legal fees and things? Or is that not the case? It's not that.
What we have decided to do is make an ex gratia payment on a global basis, recognising his costs during the 6.5-year process, the time and commitment.
The same measurement of costs then as you did in the Taina Pora case, was that you talked about sort of lost income and all those things.
It certainly doesn't include lost income. It reflects the time, the cost, the complexity, and also the desirability of avoiding future litigation. And as I've said, it's been reached on a global negotiated basis, so we're not getting into breaking up exactly what falls to what. This is a basis that's been negotiated between the parties. I can imagine there'll be a range of views in New Zealand as to the appropriateness of it, as there has been on everything in this case throughout its history. But in my view and the view of Cabinet, the desirability of bringing it to a conclusion on a basis that reflected that this process has been more difficult and has taken far longer than anyone would have wanted it to. I think it is appropriate that we recognise that in some way, and I think it is in everybody's interests that the process be brought to a close. I am of the view that we could continue to litigate this matter for many years and still not reach any greater degree of absolute certainty, and I don't see that anyone benefits from that.
Is it just hush money? Is it just, stop challenging this decision, stop taking us to court, here's some cash, shut up and go away?
Well, it's hardly that. Mr. Bain and his team obviously will have their own views and will express them. They were free to accept the settlement or not. It's not unusual for parties in litigation to reach negotiated settlements. I think we've been very open and honest with the realities that were in front of us, the details in the report, as far as we're able to be in terms of legal process. But Mr. Bain, at the end of the day, and his team have made a decision that they wish to take the offer that's on the table and bring it to a close. That is a decision they've come to freely, and they will have had their own reasons for doing that.
And is that payment entirely to Mr. Bain? It's not to cover Mr. Cowan's costs?
It's entirely to Mr. Bain. What Mr. Bain then does with it is a matter for him.
Is there a precedent for paying out something like this that isn't officially compensation with claims like this that don't meet the thresholds?
Not for compensation claims. I've got no advice of an ex gratia payment being made for previous applications for a compensation for wrongful conviction. The Crown often makes ex gratia payments. There's nothing particularly unusual in that. It often reaches payments to settle litigation. There's nothing particularly unusual in that. But in terms of this particular context, this is the first of its kind, and I think that recognises the very unique, unlikely to ever be repeated circumstances of a case like this one, which is 22 years on, and yet it continues to grip the public of New Zealand in a way that I think is absolutely unique.
Do you accept the whole process has been in shambles?
I don't accept that it's been shambles. I accept that it has taken far longer than anyone would have wanted, and there's been a range of reasons that have led to that 6.5 years. We can relitigate those, but we are where we are. My job is to try and pick up this matter and find a way through that is fair and acceptable to all the parties. I think I've done that as best as I can. I'm very pleased that the matter is concluded, and I have no doubt there will be a range of views and some very strongly held views, but nonetheless, the reality is that without some sort of agreed resolution, this matter would continue to go on, and I don't think that's in anyone's interest.
Law Professor Chris Gallagher's already come out and said that this shows that guidelines need review. Obviously, there's been talk of that in the wake of Tainapora as well. Have you given any more thought to that?
Well, in this case, Mr. Bain's case failed because he wasn't able to establish his innocence. So if the suggestion is that we should pay compensation even when someone can't prove their innocence, I would disagree with that. Whether the guidelines need review is something I'm going to give some consideration to, I think, as the Prime Minister has mentioned, but it is not something you do in the middle of applications like this. You have to do it outside of the applications you're currently working on. But if, well, I don't want to speculate on where any review might go, to remove the requirement for the party to prove innocence would be a substantial departure from the way schemes like this work around the world, and I think that's unlikely.
What does the innocence thing actually mean? Can you explain to Kiwis who will be thinking, okay, so he's not innocent, does that mean he killed his family? Can you explain what that means?
So it all comes down to what in law is called the onus of proof. So in a Crown case and in a criminal case, the Crown has to prove that the defendant, beyond reasonable doubt, committed the offence. So in this case, killed the Bain family. Now, lawyers never like putting percentages on things, but you could probably use a sort of a yardstick of perhaps 80% likelihood that the offence was committed by the person. In this case, the onus switches so that it's Mr. Bain's job to prove that he is in fact innocent. The difference is he doesn't have to prove that beyond reasonable doubt, which is that higher threshold. He has to prove it on what's called the civil standard, which is the balance of probabilities. So if you're comparing, if one is 80%, balance of probabilities is just over 50%, so more likely than not. So, I mean, the numbers are not exact, law is not a science, but I'm just giving those as a sort of a comparative. So Mr. Bain had the responsibility to prove that it was more likely than not that he was innocent. As I've said, it's not enough to simply raise other scenarios of things that could have happened or to raise doubts, that may be sufficient in a criminal case. In this case, as Mr. Callanan very clearly sets out in his report, he has the positive duty to prove his innocence, and Mr. Callanan finds that he hasn't met that threshold.
So in the balance of probabilities, the government thinks Bain did it?
The government doesn't express a view. We have been very careful not to put ourselves in a position of being judge and jury. The evidence and the fact pattern in this case is incredibly complex. That's why we have some of the most highly respected jurists in the world to consider these matters. The evidence Mr. Callanan has found is such that he hasn't proven his innocence to that level. I think where you can say is that there hasn't been a conclusive finding from this process. What we know is that there hasn't been a finding of innocence to the standard required.
Have you some people look at this and be like, the government's made its decision up right from the beginning, right from when Judith Collins threw out Binny's report that compensation shouldn't be awarded to him because he essentially did it. What would you say to that?
Look, I'd think that's completely wrong. I know for a fact that in the time, certainly that I've been running the case, and I'm sure it's true of my predecessors who went before me, both Simon Power and Judith Collins, that the government has approached this matter on the basis of wanting finality, wanting a clear resolution. In this case, that has proved to be incredibly difficult. But in all stages, the government has to make decisions based on what it believes to be reliable, robust information. The report from Mr. Binney was found by Robert Fisher to have, in his words, fundamental errors of principle that made it unsafe to act upon. With advice like that in front of Cabinet, clearly it was going to be difficult for Cabinet to decide to ignore that and just to take it anyway. That matter, as you know, went before the courts. And in early last year, Mr. Bain's team and I agreed that the best way forward at that point was to draw a line under both and start afresh. Where that process landed, I was completely agnostic about. I made no suggestion or involvement in the process at all. It was simply passed to Mr. Callanan and asked to give it his absolute considered attention, which I believe he's done. This is where he has determined it has landed. This is where we find ourselves. And today's announcement is an absolute good faith intention to bring finality to the proceedings on a basis that can be agreed between the Crown and Mr. Bain and move on.
And is there's no way, so the settlement that you've reached, that's it? There's no way they can change their mind in a year's time?
That's certainly the advice I've had.
Have you spoken to Mr. Bain, or do you plan to, and what do you say to him?
I've spoken to Mr. Bain during this process. In the last few days, as we've been concluding the negotiations, the discussion has been between advisors. But I've certainly met with Mr. Bain and Mr. Karam during this process to hear their concerns and to hear from them directly. I felt that was something they requested me to do, and I was very happy to do it. But subsequently, of course, the discussion has been between lawyers and advisors as this has been negotiated out.
Do you plan to speak to him now that this is concluded?
If he wishes to speak to me, I've certainly got no resistance to that. I think the more important thing was that I heard from him as we were working through the process. He requested that meeting and I was happy to oblige. At this stage, I can't imagine that there is a lot further to discuss, but if they made that request, I'd be happy to consider it.
What did you say to him when you last spoke?
Oh, look, largely they had asked me for the meeting, and I said that I was very happy to hear from them, hear their concerns, hear their view, talk through how they saw things. As I've indicated in my statements, they made it clear that they didn't accept Mr. Callanan's findings. I wanted to hear directly their concerns and what they thought, and talk to them about how I saw the next steps evolving, which I did, and which has led us to this point.
Do you think he did it?
I'm not going to express a view on that. I don't think it is wise for anyone who hasn't sat through all of the evidence in a judicial capacity and gone through it in the detailed, deliberative way that the jurists in this case have done to reach that view. I know many New Zealanders hold firm views on that point. I've taken the view throughout my legal career that unless you've been involved in every aspect of the evidence all the way through, it is dangerous to reach views. I've deliberately set my role as being the Minister of Justice, not being a de facto judge on the case.
I mean, you've read all three reports. You've been essentially looking at all the evidence. You know this case inside out. So
I don't think it's appropriate or sensible for me to reach or express a view on that. The day Cabinet puts itself in the role of trying to play judge and jury in these cases, I think would be a bad day. I think it's important that we let Cabinet fulfil its role and leave the role of assessing the evidence and the legal thresholds to the legal experts. Good? Thanks.